Turning now to the federal hate crimes trial out of Brunswick, Georgia, of the three white men convicted of murdering Ahmaud Arbery. Attorneys wrapped up day 3 of jury selection today for Travis McMichael, his father Gregory McMichael, and their neighbor William Roddie Bryan. They are all facing hate crimes and attempted kidnapping charges in Ahmaud's death in February 2020. The defendants have already been sentenced to life in prison for the convictions in the state trial. Joining me now to discuss this is CK Hoffler. She's the immediate past president of the National Bar Association. Thanks for staying with me here, CK. All right, during the state trial, the prosecution actually stayed away from the topic of race. But in this federal trial, race and racial profiling are big issues. Attorneys have been questioning the potential jurors about race privately outside the presence of reporters. So, CK, how challenging is this going to be for the prosecution to prove that the McMichaels and Bryan were motivated by racism when they chased and killed Ahmaud?
Well, Laverne, I think it's going to turn on the evidence that they have. And based on some of the evidence that I've seen, there is exceptionally compelling evidence that will demonstrate that this was all motivated by racial animus. Without a question, there were statements that were made at the scene of the accident. As we know, there was no real investigation because the then district attorney obstructed justice, told the McMichaels to go home and wash up, and basically prevented a full-fledged investigation. Well, during the comments that were made by the McMichaels, there was racial animus that was spewed. There were also racial comments that were made. There's a question of perhaps some text messages that contain negative information that's racially motivated. So the key is going to demonstrate bias. This is going to be, remember, you've got the underlying crime of murder that's already been proven. These people are convicted, but they've got to show that it was motivated by race and by bias. Proof positive of that fact, and the jurors may not know this, they tried to cop a plea, and Travis McMichael tried to say, yes, he did it. It was motivated by race. But of course, when people are trying to cop a plea, they'll say just about anything, in my impression. But I do think that they have sufficient evidence to be able to prove this. And it's going to turn on the evidence, and it's going to turn on whether these jurors will have an open mind to them being convicted on a related type of crime, if you will, but simply motivated by racial animus. It's not easy because, as you know, some people don't believe that there's such a thing as racism, as incredible as it is to believe.
That's what they say in public. But anyhow, it's another story. So let's talk about the jurors, CK, you mentioned. The court sent summons to more than 1,000 people, hoping to find 12 impartial jurors and 4 alternates. The defendants' guilty verdicts were widely reported in November, and just last week, the McMichaels were prepared to plead guilty, as you said, and serve some of their sentence in federal prison instead of state prison. CK, this has got to be incredibly difficult to seat a jury in this case.
It is going to be difficult because everybody knows about the case. You'd have to literally not be living in that community not to know about this case and know about the verdicts. However, because everybody knows, the question is going to be, can they set aside their feelings on the verdict, one way or the other, the verdict in the state court case, and can they rule and look at the evidence in this case and rule and reach a verdict? They're going to have to set aside all of the information that they know. Now, to me, that may almost be impossible, but this can happen because this is a different type of case. And I believe they will be able to seat 12 jurors, but it's going to be difficult because this is already a small community. Even if there had not been a state court case, just think of the time it took to pick a jury in the state court case. Now, in federal court, it's completely different. The judge, by and large, picks a jury. The judge, by and large, asks the questions. Sometimes the attorneys can ask questions, but it's a very, very different drill when it comes to jury selection, or voir dire as we call it, and federal court versus state court. So this judge is going to pick a jury, is going to ensure that a jury is in that box. And after a certain period of time, when the judge is comfortable that all of the preliminary questions, the specific questions, the general questions and the specific questions have been asked and managed by him, then by her, then there's going to be a jury.
I'm actually really glad you made that clarification about how the judge has the impact there, because I'm wondering, when it comes to the prosecution and defense attorneys, they're looking for something entirely different in their jurors. So how is that going to work here if the judge has this say?
Well, this is one of the reasons as a practitioner, I don't like being in federal court, to be very frank with you, because I'd like to be able to ask the questions, to pick a juror, to make that connection, to understand where each individual juror is coming from. In federal court, it's left up to the judge, but the lawyers typically can submit questions to the judge. There's a whole process for the lawyers to submit those questions, for the judge to go through the questions and to make a determination of which questions he or she will ask. I personally, as a practitioner, and I'm sure the prosecutor and the defense counsel don't like this either. I prefer to ask the questions myself because you're trying to establish a relationship with the jurors that's born from asking them questions about their background, about how they feel about issues. And of course, as a practitioner, you feel you can do it better than anyone to protect and be an advocate on behalf of your client. So it is very different, but if you will, both sides are equally advantaged or disadvantaged by the fact that the judge is going to do that and they won't have the opportunity to really delve and ask questions the way they would be able to in state court. It's one of those things
Mm.
that when you practice in this space, you just learn to deal with and you just suck it up and let the judge do his or her thing.
Oh, interesting. Now, Ahmaud's father, Marcus Arbery, was in court again today. We, of course, know this family. They have endured so much. They've already gone through one trial. Now they're having to sort of relive this tragedy again of their son's murder. CK, how important is it for the potential jury to actually see the victim's family in court?
It is very important because it humanizes the case. This is not a case about just a random somebody. This is someone's child. This is someone who will never sit at a dining room table, will never be able to hug his parents. His parents will never have the benefit of hugging him, hugging his children, walking down the aisle, if you will, when he gets married, seeing him graduate. None of the things that we take for granted and that we enjoy will this family be able to endure. So it's important for them to see and make that connection, even if it's just by eyes, and know that that is the father, that is the mother, this is the family. This is who has suffered. It humanizes Ahmaud Arbery because at this point, you're just hearing evidence, evidence here, evidence there, people testifying about this person, Ahmaud Arbery, who was, as we saw in the state court case, to use Travis McMichael's words, cornered like a rat. That's what they said. So in seeing the father and seeing the mother, it humanizes this person, this young man who probably suffered tremendously in the last 5 minutes of his life. The unthinkable, the unspeakable would be demonstrated through his parents and through his family.
Yeah, it's hard to even comprehend where they get the strength to do this, but thankfully they are. CK, we appreciate you joining us as always. Thank you so much for your expertise this evening.